unique in its content and spirit. The Indian Constitution is unique in its content and spirit, so borrowed from almost every constitution of the world. Since it is known as the mini constitution due to the important large number of changes made by it in various parts of the constitution. Creation in the Bharatiya is 1973. The Supreme Court ruled that the constituent power of Parliament and Article 368 does not enable it to alter the basic structure of the constitution. Constitution. The environment in British Constitution, the Constitution of India is a very comprehensive, elaborate and detailed document originated in 1941 the Constitution obtained of the aim 395 articles. The Constitution contains not only the parliamentary principle recognized but also detailed administrative provisions. Further, those matters which in other modern democratic countries have been left to the ordinary legislation or established political convention have also been included in the constitutional document itself in India, drawn from various sources. There is the Constitution. the law against that of procedure established by law contained in the Indian Constitution. shall be provided in any education institution maintained by the state. No religious instruction shall be provided in any education institution maintained by the state. The 97 Constitutional Amendment Act of 2011 gave a constitutional status and protection to cooperative societies. The 97 Constitutional Amendment Act of 2011 gave a constitutional status and protection to cooperative societies. The right to cooperative societies as amendment had included a new UPSP on promotion of cooperative societies, that is Article 43B. It added a new Part 9B in the Constitution which read societies. Part Articles 243Z, 243ZT, 243ZHC, 243ZT. The new Part 9 contains various provisions to ensure the cooperative societies in the country function in a democratic, professional, autonomous, and economically sound manner. Democratic, professional, autonomous, and economically sound manner. Border-Dongri, Maithili and Santali. Border-Dongri, Maithili and Santali were added by the 92nd Amendment Act of 2003. Border-Dongri, Maithili and Santali were added by the 92nd Amendment Act of 2003. Bodo-Dongri, Maithili, Santali. 71st Amendment Act of 1992. Konkani, Manipuri and Nepali were added by the 71st Amendment Act of 1992. And Bodo-Dongri, Maithili and Santali were added by the 92nd Amendment Act of 2003. Bodo-Dongri, Maithili, Santali were added by the 92nd Amendment Act of 2003. Bodo-Dongri, Maithili, Santali were added by the 92nd Amendment Act of 2003. Odia was renamed as Odia by 96th Amendment Act of 2011. Odia was renamed as Odia by the 96th Amendment Act of 2011. Odia was renamed as Odia by the 96th Amendment Act of 2011. Odia was renamed as Odia. Odia was renamed as Odia by the 96th Amendment Act of 2011. The schedule. With the First Amendment and protecting natural judicial scrutiny and the operation of limited. The Supreme Court ordered to protect the schedule after April 24, 1973 and now opened the judicial review in 2007. The Supreme Court ordered the schedule after April 24, 1973 and now opened the judicial review. Matters mentioned Federal Scheme Office on judiciary publicize an emergency provision and administrative detail. British Constitution, Parliamentary Form, Rule of Law, Legislative Procedure, Simultaneous Cabinet System, Prerogative, Parliamentary Privileges and Bicameral. President, High Court judges and impeachment of the President and removal of High Court and the Supreme Court judges and post of Vice President. Nomination member to the Rajya Parliament election of President. If attention of the strong that investing of President passed the President in the center. Constitution of the Supreme Court, Article 143. Constitution concurrently freedom of trade, commerce and intercourse and joint sitting of the two houses of Parliament. Australian Constitution में concurrently mention है. Australian Constitution is concurrently freedom of trade, commerce and intercourse and joint sitting of the two houses of Parliament. Australian Constitution concurrently freedom of trade, commerce and intercourse and joint sitting of the two houses of Parliament. Australian Constitution concurrently freedom of trade, commerce and intercourse and joint sitting of the two houses of the Parliament. Concurrently in the joint sitting of the two houses of the Parliament. Concurrently and joint sitting of the two houses of the Parliament. Australian Constitution the concurrently and the joint sitting of the two houses of the Parliament. The Weimar Constitution of Germany, suspension of avoiding emergency, Soviet Constitution, USSR and Russia, fundamental duties and the ideal of justice, social, economic and political in the preamble. Fundamental duties and the ideal of justice, social, economic and political in the preamble. Soviet, USSR, now Russia, fundamental duties and the ideal of justice, social, economic and political in the preamble. French Constitution, Republic, ideals of liberty, equality and fraternity. Australian Constitution concurrentness and the joint sitting of the Parliament, that is Article 108. South African Constitution, procedure for amendment of the Constitution and election of member to the Rajya Sabha, procedure for the amendment of the Constitution and the election of member to the Rajya Sabha. Japanese Constitution, procedure established by law. And America follows due process of law. Japanese Constitution, procedure established by law. Even political governance was started by them. Preamble of the Constitution. The American Constitution was the first to begin with the preamble. The American Constitution was the first begin with the preamble. Many countries, including the United States, the preamble first the introducing of preface of the Constitution contains the summary of the Constitution and the Palika and Eminent Jurists and Constitution expert called the preamble. As the identity card of the Constitution, the preamble to the Indian Constitution is based on the objectives resolution. The preamble to the Indian Constitution is based on the objectives resolution. The American Constitution was the first to begin with the preamble. Many countries, including India, followed this practice of the preamble first. The introduction of preface to the Constitution contains a summary of the essence of the Constitution and the Palika and Eminent Jurists and Constitution expert called the preamble as the identity card of the Constitution. The American Constitution was the first to begin with the preamble. The preamble was an introduction preface to the Constitution contains a summary of the essence of the Constitution and the Palika and Eminent Jurists and Constitution expert called the preamble as the identity card of the Constitution. The preamble to the Indian Constitution is based on the objectives resolution. Adopted and moved by President Nehru and adopted by the Constitutional Assembly, it has been amended by 42nd Constitutional Amendment Act of 1976, which added 3 new words: socialist, secular, and integrated. Sovereign, socialist, order, socialist, secular. Add किया गया था that socialist and secular. Sovereign. पहले से था socialist and secular. Socialist, secular ये दो चीज़ें ऐड की थी. Socialist, secular, sovereign पहले से था. Text of the preamble in its present form reads: We, the people of India, have solemnly resolved the Constitution into a sovereign, socialist, secular, democratic republic secure to all its citizens. Sovereign, socialist, secular. Sovereign, socialist, secular. Justice, social, political justice, and thus we have taken from Russia, that is USSR, liberty, authorization, faith, emotion, equality, restriction of opportunity, among them all, fraternity, specifies justice, liberty, equality, and fraternity as objective. Date of adoption of the Constitution, its president between 1949 as date. Keywords in the preamble, certain keywords, sovereign, socialist, secular, democratic, justice, liberty, equality, fraternity are explained as follows. So, in the words of an implies it is neither independence nor an opinion of any other nation, but an independence it is there is no authority above it, and it has free to conduct its own affairs, both internal and external. Though in 1949, India declared the continuation of a full membership of the Commonwealth of Nations. In 1949, India declared a continuation of a full membership of the Commonwealth of Nations and accepted British Crown as head of the Commonwealth. Though in 1949, India declared the continuation of a full membership of the Commonwealth of Nations and accepted the British Crown as head of the Commonwealth, the sixth constitutional declaration does not affect India's sovereignty in any manner. 1949, India declared a continuation of a full membership of the Commonwealth of Nations to the Commonwealth of Nations and accepted the British Crown as head of the Commonwealth. The sixth constitutional declaration does not affect India's sovereignty in any manner. The sixth constitutional declaration does not affect India's sovereignty in any manner. Further, India membership of the UN also constitutes a limitation on our sovereignty. Being a sovereign state, India can either acquire a foreign territory or cede a part of its territory in favor of a foreign state socialist, even before the term was added with the 42nd Amendment of 1976. Even before the term was added by 42nd Amendment of 1976, the Constitution artificially contained the form of DPSP. In other words, what was at the time clear in the Constitution has now been made explicit. Moreover, the Congress Party itself adopted a resolution to establish a socialist pattern of society in its Agadi session as early as in 1955 to take measures accordingly. The Congress Party itself adopted a resolution to establish a socialist pattern of society in its Agadi session as early as in 1955. State socialism, which involves nationalization of all means of production, distribution of all means of production, and distribution and abolition of private property. Democratic socialism, on the other hand, holds faith in a mixed economy where both private sector policies represent a certain concept. Democratic socialism aims to end poverty. Democratic socialism aims to end poverty, ignorance, disease, and inequality of opportunity. Democratic socialism aims to end poverty, ignorance, disease, inequality of opportunity. Indian socialism is a blend of Marxism, Gandhism, leaning heavily toward the Marxism socialism. The economic policy of liberalization, privatization, globalization has however diluted the socialist credentials of the Indian state. Secular. The term secular too was added by the 42nd Amendment of Act of 1976, however, as the Supreme Court said in 1974, although the word secular still was not explicitly mentioned in the Constitution. It can be not out of Constitution because wanted to establish the state in accordance with Article 25 to 28 guaranteeing the fundamental right to freedom of religion have been included in the Constitution. The Indian Constitution embodies a positive concept of secularism, that is, all religions in the country, irrespective of their strength, have the same status and support from the state. Democratic political stability and preamble is based on the doctrine of popular sovereignty, that is, possession of supreme power by the people. Democracies of two types, direct democracy and indirect democracy. In direct democracy, the people exercise the supreme power directly, as is the case in Switzerland. There are 4 devices of direct democracy, that is, referendum, initiative, recall, and plebiscite. For settlement by the referendum is a procedure where proposed legislation is reported to the electorate for settlement by the direct vote. A referendum is a procedure whereby proposed legislation is referred to the electorate for settlement by the direct vote. Referendum is a procedure whereby proposed legislation is referred to the electorate for settlement by the direct vote. A referendum is a procedure whereby proposed legislation is referred to the electorate for settlement by the direct vote. Referendum is a procedure whereby proposed legislation is referred to the electorate for settlement by the direct votes. It's a means of which people can propose a bill to the legislature for enactment. Initiative is a means of which people can propose a bill to the legislature for enactment. Initiative is a method by means of which people can propose a bill to the legislature for enactment. Initiate करना referendum electorate को भेजना तो settlement by direct vote. Electorate में भेजना so that it can be settled by direct vote, so that it can be settled, so that it can be settled by direct vote, so that it can be settled by direct vote, so that it can be settled by so that it can be settled by direct vote, so that it can be settled, so that it can be settled by direct, so that it can be settled by direct vote, so that it can be settled by referendum is a procedure where proposed legislation is referred to the electorate for settlement by direct vote. Initiative is a method by means of which people can propose a bill to the legislature for enactment. Recall is a method by means of which the voters can remove a representative or an officer before the expiry of his term when he fails to discharge his duties. Recall is a method by means of which the voters can remove a representative or an officer before the expiry of his term when he fails to discharge his duties properly. Plebiscite is a method of obtaining the opinion in India. So, opinion in the eyes of people on any issue of importance. It is only used to solve the trade or dispute. And the method of obtaining the opinion of people of India. Plebiscite is a method. Plebiscite is a method of obtaining the opinion of people of India on any issue of public importance. It is generally used to solve the territorial dispute. It is generally used to solve the territorial disputes. Democracy on the other hand, the representative. Democracy is of two kinds, that is parliamentary and presidential. Parliamentary democracy, under which the executive is responsible to the policy of the national and universal agencies, periodic election, rule of independence of judiciary, and absence of discrimination on certain grounds of the manifestation of the democratic character of the Indian polity. The term democratic is used in the preamble in the broader sense, embracing not only also social and economic democracy. The term democratic is used in the preamble in the broader sense, embracing not only political democracy but also social and economic democracy. Liberty, equality, and fraternity. The principle of liberty, equality, and fraternity are not to be treated as separate items in a trinity. Justice, social, economic, and political has been taken from the USSR. Liberty cannot be diverse from equality. Equality cannot be diverse from liberty. And not only liberty and equality be diverse from fraternity. Without equality, liberty would produce the supremacy of the few over the without equality, liberty would produce the supremacy of the few over the many. Equality without liberty would kill. Without equality, liberty would produce the supremacy of the few over the many. Equality without liberty would kill. Equality without liberty would kill individual initiative. And the same what is the Supreme Court of Justice 1997 that the Constitution envisions establishing egalitarian social order and integration, social, economic, and political justice and a social and economic democracy of the Bharat Republic. Categories: monarchy and republic. In a monarchy, the administrator usually can go and just elected to position as he comes into office to succession. Example, written in a republic. On the other hand, the head of the state is always elected directly or indirectly for a fixed period. That is USA. In a republic, on the other hand, the head of the state is always elected directly or indirectly for a fixed period. Example, USA. In a republic, on the other hand, the head of the state is always elected directly or indirectly for a fixed period. Example, USA. For the term of India has an elected called the president. He is elected indirectly for a period of 5 years. The republic also means to investing of political sovereignty in the people and not in single individual liking. Second, the absence of any privilege laws and all public affairs being open to every citizen without any discrimination. Justice, the term justice in preamble embraces three distinct forms: social, economic, and political. Secures the various provision of fundamental rights and DPSPs. Justice is on the preambling basis of distinct forms: social, economic, and political. Social justice denotes the equal treatment of all citizens without any social distinction. Social justice denotes the equal treatment of all citizens. Caste, color, race, religion, sex, and so on. It means absence of privileges when extend to any particular section of the society and improvement in the condition of backward classes, SC, ST, and OBCs, and women. Economic justice denotes the non-discrimination between people on the basis of economic factors. It involves the elimination of glaring inequalities in wealth, income, and property. A combination of social justice and economic justice denotes what is known as distributive justice. Political justice implies that all citizens should have equal political rights, equal access to all political offices, and equal voices in the government. The ideal of justice, social, economic, and political, has been taken from the Russian Appellation Act in 1917. Liberty means the absence of restraints on the activities of an individual and at the same providing opportunities for the development of individual personality. The term liberty means the absence of restraints on the activities of an individual and at the same time personality is the claim which is of the reasonable and important that expression belief is the notion of the fundamental liberty is essential with the successful functioning of the liberty system. However, the liberty should be licensed to vote on license and has to be enjoyed within the limitation mentioned in the Constitution itself. In brief, liberty conceived by the Parliament of fundamental right is not absolute but qualified. The ideal, in brief, the liberty conceived by the preamble of fundamental right is not absolute but qualified. The ideas of liberty, equality, and fraternity in our preamble have been taken from the French Revolution, and the idea of liberty, equality, and fraternity, and the idea of liberty, equality, and fraternity has been taken from the French Revolution from 1700 and 1890 to 1799. Equality. The term equality means the absence of special privilege to any section of the society and the provision of adequate opportunities for all individuals without any discrimination. The principle is to all citizens of India equality of status and opportunity. This provision of race and state dimension of equality, civic, political, and economic. The following provision of the chapter on fundamental rights ensures civic equality before the law. Article 14. The following provision of the chapter on fundamental rights ensures civic equality before the law. Article 14. When a person is to be declared ineligible for the inclusion electoral votes on the grounds of religion, race, caste, or sex, Article 325. To elections of the Lok Sabha and the state assemblies to be on the basis of adult suffrage, that is Article 326. No person is to be declared ineligible for inclusion in electoral roll on grounds of religion, race, caste, or no person is to be declared ineligible for inclusion in electoral roll on grounds of religion, race, caste, or sex. Article 325. To elect Lok Sabha and state assemblies to be on the basis of adult suffrage. Article 326. In the Berewari Union Case 1960, the Supreme Court said that the preamble shows the general purpose behind the several provisions in the Constitution. It determines that the makers of the Constitution for whether terms used are ambiguous or capable of more than one meaning. Some assistance or interpretation may be taken from the objective enshrined in the In the Berewari Union Case 1960, the Supreme Court said that the preamble shows the general purpose behind the several provisions in the Constitution, and it's also key to the minds of the makers of the Constitution for whether terms used in any article are ambiguous or capable of more than one meaning. Some assistance or interpretation may be taken from the objective enshrined in the preamble. Despite this recognition of the significance of the preamble, the Supreme Court specifically opined that preamble is not a part of the Constitution. So in Berewari Union Case 1960, Supreme Court opined that preamble is not a part of the Constitution. And the case case 1973, the Supreme Court rejected the earlier opinion that preamble is a part of the Constitution, but also that preamble is of extreme importance. The Constitution should be read and interpreted in the light of the grand provision expressed in the preamble. In the Rise of India case also, the Supreme Court again held that preamble is an integral part of the Constitution. In conformity, the Constitution is adopted by the Constitutional Assembly. Opinion held by the Supreme Court that the preamble is part of the Constitution is in consonance with the opinion of the fundamental Constitution. The preamble is neither a source of power to legislation nor a prohibition upon the powers of legislature. It is non-justiciable that its provisions are not enforceable in the court of law. It is non-justiciable that its provisions are not enforceable in court of law. Berewari Union Case 1960, किशन भारती केस 1973 इसमें प्रूव कर दिया गया था। LIC केस 1990 cannot be amended as it is not part of the Constitution. The petition contended that the cannot be used to destroy the basic element of fundamental feature of the Constitution, which is enshrined in the preamble. Preamble can be amended subject to the condition that no amendment is done to the basic structure. The court held that the basic elements of the fundamental features of the Constitution as contained in the preamble cannot be altered by an amendment under Article 68. The preamble has been amended only once over in 1976 by the 42nd Constitutional Amendment Act, which had added 3 new words: socially, secular, and integrity to the preamble. This amendment was held to be valid. The preamble has been amended only once over in 1976 by the 42nd Constitutional Amendment Act, which has added 3 new words: socially, secular, and integrity. Burma, Sri Lanka, Pakistan. Fundamental rights. Fundamental rights are enshrined in Part 3 of the Constitution, Article 12 to 35. The fundamental rights are enshrined in Part 3 of the Constitution, Article 12 to Article 35. In this regard, the premise of the Constitution direct inspiration from the Constitution of USA, that is Bill of Rights, and Part 3 of the Constitution provided for 7 fundamental rights. Originally, the Constitution provided for 7 fundamental rights. Originally, the Constitution provided for 7 fundamental rights, that is right to equality, right to freedom, right against exploitation. Originally, the Constitution provided for 7 fundamental rights: equality, freedom, against exploitation, right to They are not absolute, but they are qualified. The state can impose reasonable restrictions on them. The state can impose reasonable restrictions on them. The state can impose reasonable restrictions on them. They are not absolute, but qualified. The state can impose reasonable restrictions on them. They are not absolute, but they are qualified. The state can impose reasonable restrictions on them. They are not absolute. Instead, they are qualified. The state can impose reasonable restrictions on them. However, whether such restrictions are reasonable or not is to be decided with court as there is a balance between the rights of individual and of the society as a whole, individual liberty and social control. constitution. Hence, the aggrieved person can directly go to the Supreme Court, not necessarily Article 300. Or external aggression not on the ground of harm to building data and emergency suspension of fundamental liberties and national emergencies explained in detail in chapter 16. Such a law can be made only by the Parliament and not by a state legislature throughout the country as amended in Article 35. Definition of state. Definition of state. The term state has been used in different provisions concerning the fundamental rights. Article 12 defines the term for the purpose of Part 3. The term state has been used in different provisions concerning the fundamental rights. Hence, Article 12 defines the term for the purpose of Part 3. Working as an instrument in the survey of votes within the meaning of the state under Article 12. According to the Supreme Court, even a private body or an agency working as an instrument of the state falls within the meaning of state under Article 12. Laws inconsistent with fundamental right. Article 13 declares that all the laws that are inconsistent with or in derogation of any of the shall be void. Article 13 declares that all laws that are inconsistent with or in derogation of any of the fundamental right. Article 13 declares that all laws that are inconsistent with or in derogation of any of the fundamental rights shall be void. In other words, it explicitly provides for the doctrine of judicial review. This power has been conferred on the Supreme Court, Article 32 and High Court, Article 26, that can declare a law unconstitutional and invalid on the ground of contravention of any of the FR. That can declare a law unconstitutional and invalid on the ground of contravention of any of the fundamental rights. The term law in Article 13 has been given a wide connotation so as to include the following. Article 13 has been given a wide connotation so as to include the following. Permanent laws enacted by the Parliament of the state legislature, temporary laws like ordinances issued by the President of the state governor, statutory instrument in the nature of delegated legislation, executive legislation like order, bylaw, rule, regulation, notification, non-legislative sources of law, that is custom or usual having the force of law. This is not only a legislation, but any of the above can be challenged. The court is violating a fundamental right and hence can be declared as valid. Further, Article 13 declares that a constitutional amendment is not a law and hence cannot be challenged. However, the Supreme Court held a case on the Bharti case 1973 that the constitutional amendment can be challenged on the ground that it violates a fundamental right and forms a part of the basic structure. However, the Supreme Court held in the case on the Bharti case. However, the Supreme Court held in the case on the Bharti case 1973 that a constitutional amendment can challenge the ground and violate the fundamental right and forms a part of the basic structure. The constitutional amendment is not a law, but however, the Keshwan the Bharti case, in the Keshwan the Bharti case, 1973, it was declared the constitutional amendment can be challenged and the ground and violate the fundamental right and forms a basic part of the basic structure of the constitution, and here it can be declared as void. If it affects the basic structure of the constitution, then only. And right to equality, obviously equality of law and equal protection of law. Obviously, opposite of concept equality before law, protection and democratic potency state shall not deny any person equality before the law, the equal protection of the laws within the territory of India. This provision concerns all persons with the citizens of honors, with the word person includes legal persons, that is statutory corporation, companies, registered societies, or any other type of legal person. Moreover, the word person includes legal person, that is statutory corporation, companies, registered societies, or any other type of legal person. The concept of equality before law is a British origin, where the concept of equal protection of law has been taken from the American Constitution. The first concept connotes the absence of any equality before law, that is, the absence of any special privileges. The equal protection of all persons under the ordinary laws of the land administered by ordinary law court, and no person with a richer or higher law, official and non-official, is above the law. The second concept, on the other hand, that is equal protection of laws, equal treatment under equal circumstances, the privilege conferred liabilities imposed by the law. In some ways, application of the same laws to all persons which are similarly situated and alike should be treated alike without any discrimination. This is the former letters of other concepts, both of them aim to establishing equality of legal status, opportunity, and justice. The Supreme Court held that where equals and unequals are treated differently. The Supreme Court held that where equals and unequals are treated differently, Article 14 does not apply. The Supreme Court held that where equals and unequals are treated differently, Article 14 does not apply. Article 14 forwards class legislation, forwards reasonable classification of person. Well, Article 14 forwards class legislation permits reasonable classification of person objects on transaction by the law. But the classification should not be arbitrary, artificial, or evasive. Rather, it should be based on intelligible, differential, and substantial distinction. Rule of law. The concept of equality before law is an element of the concept of rule of law propounded by A.V. Dicey. The British, that is the concept of the potency limits the absence of arbitrary power. That is, no man can be punished except for a breach of law. Equality before the law, that is equal separation of powers, that is more higher law official and non-official, that is the ordinary law of the land administered by the ordinary law court. Equality before the law, that is equal subjection of all citizens, which is more higher law official and non-official, to the ordinary law of the land administered by the ordinary law court. The primacy of the right of the individual, that is the constitution, as the result of the right of the individual as defined and enforced with the court of law, rather than the constitution being the source of the individual right. The first and the second element are applicable to the Indian system. The Indian system, and not the third one, the Indian system, the constitution is the source of the individual right. India became constitution as the source of the individual right. The Supreme Court held that the rule of law, as embodied in Article 14, is the basic structure of the constitution, as it cannot be destroyed even by an amendment. For available only to citizens and not to foreigners. Say first citizens को जो मिलता है Article 15, 16, 19, 20 and 30 only to citizens, that is 15, 16, 19, 20 and 30, 15, 16, 19, 20 and 30, 15, 16, 19, 20 and 30 only to citizens, that is only to citizens, that is 15, 16, 19, 20 and 30 upon the August 20 and 30, 15, 16, 19, 20 and 30 only to citizens. Exceptions to equality. The rule of equality before law is not absolute and there are constitutional and other exceptions to these are mentioned by the President of India, the Governor of State enjoys the following immunities: the President of India and the Governor of State. The President of India, also Governor of State, enjoys the following immunities, that is Article 361. No criminal proceeding shall be instituted or continued against the President of the Governor in any court during his term of office. No process for the arrest or imprisonment of the president or the governor shall be issued to any court during the term of office. No civil proceedings against the president or the governor shall be instituted during his term of office in any court. Proceeding in any court in respect of the publication in a newspaper or by radio or television of a substantial report of any proceeding of either of the parliament or either of the legislature of a state. Article 361A. No member of parliament shall be liable to any proceeding in any court in respect of anything said or anything, any vote given by parliament or any committee thereof. Article 105. No member of the legislature of a state shall be liable to any proceeding in any court in respect of anything said or anything, any vote given by him in the legislature and any committee thereof. Article 100. Article 31C is an exception to Article 14. Article 31C is an exception to Article 14. It provides that the laws made by the state for implementing the DPS are contained in Clause B or Clause C of Article 39 cannot be challenged on the ground that they are violative of Article 14. Article 31C is an exception of Article 14. It provides that laws made by the state for implementing the DPS be mentioned in Article 39, Clause B and C cannot be challenged on the ground that they are violative of Article 14. The Supreme Court held that where Article 31C comes in, Article 14 overloads of Article 31C आता है, Article 14 goes out. Where Article 31C comes in, Article 14 goes out. The Supreme Court held that where Article 31C comes in, Article 14 goes out. Where Article 31C comes in, Article 31C, the Supreme Court held that where Article 31C comes in, Article 14 goes out. The Supreme Court held that where Article 31C comes in, Article 14 goes out. The foreign sovereign tourism rights and civil proceedings, the UN and its agencies and the diplomatic immunity. Prohibitions of discrimination on certain grounds. Article 15 provides that the state shall not discriminate against any citizen on grounds only of religion, race, caste, sex, or place of birth. Article 15 provides that the state shall not discriminate against any citizen on grounds only of religion, race, caste, sex, or place of birth. The crucial words in the provision are discrimination and only. The word discrimination means to make an adverse distinction with regard to or to distinguish unfavorably from others. The use of the word only connotes that discrimination on the grounds is not prohibited. The use of the word only connotes that discrimination on other ground is not prohibited. The second provision of Article 15 says that no citizen shall be subject to any disability, liability, restriction, or condition on grounds only of religion, race, caste, sex, or place of birth. With regard to access to shop, public restaurant, hotel, places of public entertainment, the use of wells, tanks, bathing guards, and road and places of public resort maintained wholly or partly by state for not dedicated the use of general public. Shop, public restaurant, hotels, and places of public entertainment, well, tanks, bathing guards, wholly or partly by state for not dedicated the use of general public. This provision prohibits discrimination both by the state and the private individual, both by the state and the private individual. By the former, जो पहले वाले हैं, it provision prohibits discrimination only by the state. Access to shop, public restaurant, hotels, and places of public entertainment. It stops discrimination from it prohibits discrimination from only by the state और यहाँ पे also by the state and private individuals. There are 4 exceptions to this general rule of non-discrimination. Making a special provision for women and children, for example, reservation on seat for women, local bodies, a provision for free education for children. The state is permitted to make a special provision for the advancement of any socially and educationally backward classes of religion or for the scheduled castes and scheduled tribes. The state is permitted to make any special provision for the advancement of any socially or educationally backward classes of religion or for the scheduled castes and scheduled tribe. The present reservation seat or fee concession in public education institution. The state is empowered to make any special provision for the advancement of any socially and educationally backward class of citizen or for the scheduled caste or scheduled tribe regarding their admission to education institution, including private education institution with rated or honored with the state except minority education institution. The state is permitted to make any special provision for the advancement of socially and educationally backward class of religion or for the scheduled caste and scheduled tribe. Fee concession and public education institutions. The state is permitted to make a special provision for the advancement of any socially and educationally backward class of religion or for the scheduled caste and scheduled tribe, for example, reservation of seats or fee concession and public education institution. The state is empowered to make for the advancement of any socially and educationally backward class of religion or for the schedule cast or schedule regarding their admission to education institution. यहाँ पे reservation of seats or fee concession regarding their admission to education institution, and here it is mentioned regarding their admission to education institution. In a private education institution, whether it is unaided, the state except minority education institution, the state is about to make any special provision for the advancement of any economically weaker section of the state is empowered to make any special provision for the advancement of an economically weaker section. Institution for the state is allowed to make a provision for the reservation of up to 10% of seat for such section and admission to education institution, including private education institution. And this reservation of up to 10% would be in addition to the existing reservation. For this purpose, economically weaker section would be notified with the state from time to time on the basis of family income and other indicators of economic disadvantage. And reservation for OBCs in education institution of exception was added by the 93rd Amendment Act of 2005. Reservation for OBCs in education institution. The above exception was added by the 93rd Amendment Act of 2005. Constitutional Amendment Act of 2005. The Central Education Institution Reservation and Admission Act 2006 providing a quota. 93rd Amendment Act of 2005. 93rd Constitutional Amendment of 93rd CAA of 2005. In order to give effect to this provision, the Centre enacted the Central Education Institution Reservation and Admission Act 2006, providing a quota of 27% for candidates belonging to the OBCs in all central education institutions, including the IITs and IIMs. In April 2008, the Supreme Court upheld validity of both. In April 2008, the Supreme Court upheld the validity of the both. In April 2008, the Supreme Court upheld the validity of both the Amendment Act and the OBC Court. But the court directed the central government to exclude the creamy layer conception of the OBCs while implementing the law. The following different categories of people belong to creamy layer among OBCs and thus will not get the quota benefit. 93rd Amendment Act of 2005. It was added by the 93rd. It was just added by the 93rd Amendment Act of 2005. It was added by the 93rd Constitutional Amendment Act of 2005. The children of the following different categories of people belong to creamy layer among OBCs and thus will not get the quota benefit. Persons holding constitutional posts like President, Vice President, Judges of Supreme Court, High Court, Chairman, Member of UPSC, SPSC, Group B class officer of All India Central State Service and employees holding equivalent person BSc Bank Insurance Organization. One in the rank of Colonel of the Army and equivalent person and they are person of paramilitary forces profession like doctors, lawyers, engineers, artists, author, consultant, and so on. Person engaged in trade, business, and industry. Persons who are engaged in trade, business, and industry. People owning agricultural land of a certain limit and vacant land or building an urban area. Person having gross annual income of more than 8 lakh or possessing wealth above the exemption limit. In 1993, when the creamy layer ceiling was introduced, it was 1 lakh. In 1993, when the creamy layer ceiling was introduced, it was 1 lakh. It was subsequently raised from 2.5 to 4.5 to 6 to 8 lakh in 2017. Reservation for EWS and education institution. The above exception was added by the 103rd Constitutional Amendment Act of 2019, 103rd of 2005 and 103rd Constitutional Amendment Act of 2019. In order to give effect to this provision, the central government issued an order providing 10% reservation to the EWS and admission to education institution. The benefit of this reservation can be able with the person belonging to EWS who are not covered under any of the existing scheme of reservation for SCs to OBC eligibility criteria. And this regard is as follows. Person whose family has gross annual income of over 8 lakh are to be identified as EWS for the benefit of public employment, equality of opportunity and public employment. Article 16 provides for equality of opportunity for all citizens in matters of employment or appointment to any office under the state. Article 16 provides for equality of opportunity for all citizens in matters of employment or appointment to any office under the state. Article 16 provides for Article 16. Article 16 provides for equality of opportunity. Article 16 provides for equality of opportunity. Article 16 provides for equality of opportunity for all citizens. Article 16 provides for equality of opportunity. Article 16 provides for equality of opportunity for all citizens in matters of employment or appointment to any office under the state. Article 16 provides for equality of opportunity for all citizens in matters of employment or appointment to any office under the state. No citizen can be discriminated against or taken eligible for any employment or office under the state on ground of only religion, race, caste, sex, place of birth. Decent is mad हो गया. The general equality of opportunity in public employment. That is, Parliament can prescribe residency as the condition for certain employment or appointment in a state or union territory or local authority or other authority. As the public employment requirement is to Residence Act of 1957 expired in 1974, there is no such provision for any state except Andhra Pradesh and Telangana. Inserted by 32nd Constitution Amendment of 1973. The state can provide for reservation of appointment or post in favor of any backward class that is not adequately represented in the state service. Mandal Commission after 1979, the Morarji Desai government appointed the second backward class commission. In January 1953, Jawaharlal Nehru In January 1953, Jawaharlal Nehru set up first backward class commission under the chairmanship of Kaka Kalekar. First backward class commission under the chairmanship of Kaka Kalekar. In 1979, the Morarji Desai government appointed the second backward class commission under the chairmanship of V.P. Mandal, a member of Parliament in terms of Article 340 of the Constitution to investigate the condition of the socially and educationally backward classes and suggest measures for their advancement. The commission limited its support in 1980 and identified as many as 3,740 classes socially and educationally backward classes that constitute nearly 52% component of the population, excluding the SC and SD. The commission recommended for reservation of 27% government for the OBCs, so that total reservation for all SC, ST, OBC amounts to 50%. It was after 10 years in 1990 that the represent government declared a reservation of 27% government job for for the OBCs again in 1991. The reference to the poor section among the OBCs and 27% quota adoption of the economic criterion blending reservation. Reservation within the 10% of job for poor economically backward section of higher caste who are not covered by any existing scheme of reservation. The famous Montreal case 1992. The scope and extent of Article 16 Clause 4, which provides for reservation of jobs in favor of backward classes, has been examined thoroughly by the Supreme Court. The Supreme Court has rejected additional reservation of 10% for poor section of higher caste, set up by the constitutional validity of 27% reservation for the OBC with certain conditions, that is, the advanced section among the OBCs, a creamy layer should be list of beneficiaries, no reservation and promotion. Reservation should be confined to initial appointment only. Any increasing reservation promotion can continue for 5 years only. For reservation and promotion, the total reserve quota should not exceed 50%. The total reserve quota it should not exceed 50%. The total reserve quota should not exceed 50% except in some extraordinary situation. The total reserve quota should exceed 50% except in some extraordinary situation. This rule should be applied every year. The carry forward in case of unfilled or backlog vacancy is valid, but it should not violate 50%. A permanent statutory body should be established in compliance of over-inclusion and inclusion in the list of OBC. With regard to the good ruling of the Supreme Court, the government has taken the following action. Ramanand Committee was appointed to identify the creamy layer among the OBCs. To identify the creamy layer among the OBCs, Ramanand Committee to identify the creamy layer among the OBCs. Ramanand Committee was appointed to identify the creamy layer among the OBCs. Committed its support in 1993, which was accepted by the committee. Ramanand Committee, which was appointed to identify the creamy layer among the OBCs, committed its support in 1993, which was accepted. National Commission for Backward Classes was established in 1993. An act of Parliament, its mandate was to examine the complaints of under-inclusion or inclusion of any class of studies in the list of backward classes for the purposes of reservation. Later, the 102nd Constitutional Amendment Act of 2018 conferred a constitutional status on the Commission. 1993 was established by the 102nd Second Amendment Act of 2019 इसको constitutional status मिल गया था, that is National Commission for Backward Classes. It was established in 1993. It was established in 1993, but later it got the constitutional status by the 102nd Constitutional Amendment Act. For this purpose, and also as its function for this purpose, the amendment inserted a new article, that is 338B in the Constitution, in order to nullify the ruling with regard to reservation and promotion. That is, the 77th Amendment Act was enacted in 1995. It added a new provision in Article 16. It empowers the state to provide for reservation and promotion for of any services under the state in favor of the SC and ST that are not adequately represented in the state service. Again, the 85th Amendment Act of 2001 provides for consequential not in the case of promotion by virtue of rule of reservation for the government servants belonging to the SC ST with retrospective effect from June 1995. The rule with regard to backlog vacancy was nullified by the 85th Amendment Act of 2000. It added another new provision, Article 16, that empowers the state to consider the unfilled reserve vacancies of a year as a separate class of vacancies. जो backlog vacancies थी उसको treat किया जाएगा to be as the separate class of vacancies to be filled up in any succeeding year or year. Such class of vacancies are not to be combined with the vacancies of the year, okay, in which they have been filled up to determine the ceiling of 50% reservation on total number of vacancies of that year. Such class of vacancies are not to be combined with the vacancies of the year in which they are being filled up to determine the ceiling of 50% reservation on total number of vacancies of that year in B by times the 50% ceiling of reservation in backlog vacancies. It ends the 50% ceiling of reservation in backlog vacancies and कर दिया था. The ruling with regard to backlog vacancies was nullified by the 81st Amendment Act of 2000. It added another new provision in Article 16 that empowers the state to consider the unfilled reserve vacancies of a year as a separate class of vacancies to be filled up in any succeeding year or years. Such class of vacancies are not to be combined with the vacancies of the year. Such class of vacancies are not to be combined with the vacancies of the year in which they are being filled up. Ceiling of 50% reservation on total number of vacancies of that year. In brief, in NC 50% ceiling backlog vacancies, the 76th Amendment Act of 1994 displays the Tamil Nadu Reservation Act of 1994 in the 9th schedule to protect it from judicial review, as it provided for 6 69% of reservation, far exceeding than 50% ceiling. This is important कि 76th Amendment Act of 1994 has placed the Tamil Nadu Reservation Act of 1994 in the 9th schedule to protect it from judicial review, as it provided for 69% of reservation. Nullify the reservation, nullify the ruling with the reservation and promotion. Reservation and promotion, to nullify in order to nullify the ruling with the reservation and promotion. Services, okay. The ruling with regard to backlog vacancies was nullified. Or 76th Amendment Act of 1994 has placed the Tamil Nadu Reservation Act of 1994 in the 9th schedule to protect it from judicial review, as it provided for 69% of reservation, bar exceeding the 50% ceiling. Reservation for EWS in the public employment, the above exception D. The Third Amendment Act of 2019. In order to give effect to this provision, the central government issued an order providing 10% reservation to the EWS in civil person services in the government of India. The above exemption D was added with the 103rd Amendment Act of 2019 in order to give effect to this provision. The central government issued an order. In 1976, in 1976, in 1976, in 1900, in 1976, in 1976, the untouchability. In 1976, the Untouchability Offences Act 1955 has been comprehensively amended and renamed as Untouchability Offences Act 1955. In 1976, the Untouchability Offences Act 1955 has been comprehensively amended and renamed as the Protection of Civil Rights Act 1955. In 1976, the Untouchability Offences Act 1955 has been renamed as In 1976, the Untouchability Offences Act 1955 has been comprehensively amended and renamed as Protection of Civil Rights Act 1955 to enlarge the scope and make penal provision more stringent. The Act defines civil right as any right accruing to a person by reason of the abolition of untouchability by Article 17 of the Constitution. The term untouchability has not been defined either in the Constitution Act. However, the Mysore High Court held that the subject matter of Article 17 is not untouchability in its literal or grammatical sense, but the practice as it had developed historically in the country. It refers to the social disabilities imposed on the class of a person by reasons of their birth in certain cases, and it does not cover social work of an individual or the exclusion from military service, etc. The Supreme Court held that the right under Article 17 is available against private individual, and it is constitutional obligation of the state to take necessary action to ensure the state is not violated. Amendment of title Article 18 abolishes titles and makes 4 provisions in that regard. It prohibits that state from conferring any title except a military or a grand essential on any body, whether a citizen or a foreigner. It prohibits a citizen of India from accepting any title from any foreign state. A foreigner holding any office of profit or trust in another state cannot accept any title from any foreign state without the consent of the president. No citizen or foreigner holding any office of profit or trust in another state has to accept any present embodiment or office from or under any foreign state without the consent of the president. From the clear that the hereditary title of nobility like Maharaja Raj, Vajraya Sahib, Divan Madhya, etc., which are all conferred by colonial state were banned by Article 18 as these are against the principle of equal affixes to the names. It told that they are not violated. They are not violated particularly. Titles जैसे कि भारत रत्न, पद्म विभूषण, पद्म भूषण and पद्म श्री. However, it also told that they should not be used as affixes or prefixes to the names of awardees, otherwise they should forfeit the award. These national awards were instituted in 1954. These national awards were instituted in 1954. These national awards were instituted in 1954. Jayanta Patika Monaji decided to continue them in 1977. These national awards were instituted in 1954. These national awards, such as the Bharat Ratna, Padma Vibhushan, Padma Bhushan, Padma Shri, these are constituted in the year 1954. The Janata Party government had recognized this and discontinued them in 1977, but they were again revived in 1980, 78, 79 में नहीं दिए गए थे, 93 to 97 तक नहीं दिए गए थे, 97, 1978, 1979, 1993 to 1997. 78, 79, 1993 to 1997, 73, 78, 79, 78, 79, 1993 to 1997, 1978 to 1979, 1993 to 1997, 1978 to 1979, 1978, 1979, 1993 to 1997. Protection of civil rights. Article 19 guarantees to all citizens that the six rights is the right to freedom of speech and expression. A right to freedom, protection of six rights. Article 19 guarantees to all citizens the protection of six rights. Article 19 guarantees to all citizens the six rights is the right to freedom of speech and expression, a right to assemble peacefully and without arms. Freedom of speech and expression, right to assemble peacefully, right to freedom of speech, right to freedom of speech, assemble, right to freedom of speech, 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 then assemble peacefully, right to assemble peacefully and without arms, right to assemble peacefully, right to assemble peacefully and without arms, right to form association or unions or cooperative societies, right to freedom of speech, right to freedom of speech, right to assemble peacefully, right to form association or union, right to speech, right to speech, right to speech, right to assemble, right to speech, right to assemble, right to form association or union or cooperative society, right to speech हो गया, then right to assemble हो गया, then right to form association or union or cooperative society, right to move freely throughout the territory of India, right to reside and settle in the territory of India, right to practice any profession or to carry on any occupation, right of license for reason. Article 19 contains 7 right with the right to acquire, hold and dispose of property was related with the 44th Amendment Act of 1978. These six rights are protected against only state action. These six rights are protected against only state action and not private individual. These six rights are protected against only state action and not private individual. These six rights are protected against only the state action and not the private individual. These six rights are protected against only state action and not private individual. Moreover, these rights are available only to the state and to shareholders of a company. But not a foreigner, so legal person or 16, 19, 20, 36, 9, 15, 16, 19, 20, 30. 15, 16, 15, 16, 19, 20, 30. Once mentioned, any other grounds. Freedom of speech and expression. Freedom of speech and expression, it implies that every citizen has the right to express his views, opinions, belief, and conviction really with the word of mouth, writing, printing, picturing, or any other manner. The Supreme Court held that the freedom of speech and expression includes the following: right to protect one's views as well as views of others, freedom of the press, freedom of commercial advertisement, right against tapping of telephone conversation, right to delegates, that is government has no monopoly on electronic media, right to delegate, that is government has no monopoly on electronic media, right to delegate, that is government has no monopoly on electronic media, right against ban called by a political party organization, right to know about government activity, freedom of silence, right against imposition of free censorship in a newspaper, Right to demonstration or picketing but not right to strike. Right to demonstration or picketing, that is another but not right to strike. The state can impose reasonable restriction on the exercise of freedom of speech and expression on the ground of sovereignty, integrity of India's security. The state can legislation with violence, state of public order, decency or morality, contempt of court, defamation and incitement to any offence. Freedom of assembly, speech, expression, assembly. Every citizen has the right to assemble peaceably and without includes the right to hold public demonstration and take out procession. Assemble peacefully without arms. It includes the right to hold public meeting, demonstration, and take out procession. This freedom can be exercised only on public land, and the assembly must be peaceful and unarmed. This provision does not protect violent, disorderly, riotous assemblies or one that cause breach of public peace or one that involve harm. This right does not include the right to strike. This right does not include the right to strike. The state can impose reasonable restrictions on the exercise of it, including the maintenance or traffic in the area concerned. Under Section 144 of the CPC, Criminal Procedure Code, a magistrate can restrain an assembly, meeting, or procession if there is a risk of obstruction, annoyance, or danger to human life, health, or safety, or a disturbance of the public tranquility or riot, or any affray under Section 141 of the IPC, as a of 5% becomes unlawful if the object is IPC Section 141. So that forcibly occupies property of some person to commit any mischief or criminal trespass, to force some person to do an illegal act, and to threaten the government or its official on exercising lawful powers. Next is freedom of association. All citizens have the right to form association or unions or freedom of speech and expression, freedom to assemble, freedom of association. All citizens have right to form association or unions or cooperative society. It includes the right of political parties, companies, partnership firms, societies, club, organization, trade union, or any body of person. Not only includes the right to start an association or union, but also to contribute the association as such, whether it covers a negative right of not to form or join an association or union. These competition can impose on the exercise of this right which the state on the grounds of sovereignty and integrity of the public order and morality. Subject to these restrictions, the citizen of complete liberty to form association or union for pursuing lawful objective or purpose. However, the right to obtain recognition of the association is not a fundamental right. The Supreme Court held that the trade union have no guaranteed right to effective bargaining or right to strike or right to declare a lockout. The right to strike can be controlled by an appropriate industrial law. Freedom of movement. Freedom of movement. The freedom and the items of liberty to move freely throughout the territory of the country. He can move freely from one state to another or from one place to another within a state. This right underline the idea that India is also one unit so far as the citizens are concerned. Thus, the purpose is to promote national feeling and not parochialism. The grounds of imposing reasonable restriction on the freedom are two, namely the interest of general public and the protection of interest of any scheduled tribe. दो हैं, that is the interest of general public and the protection of interest of any scheduled tribe. The entry of outside and tribal areas is restricted to protect the distinctive culture, language, custom and manner of scheduled tribe and to safeguard their traditional vocation and properties against exploitation. The Supreme Court held that the freedom of movement of prostitute can be restricted on the ground of public health and in the interest of public morale. The Bombay High Court validated a restriction on the movement of person affected by AIDS. The freedom of movement has two dimensions, that is internal right to move inside the country and external right to move out of the country and right to come back to the country. Article 19 protects only the first dimension, that is right to move inside the country. The second dimension is held by Article 21, that is right to life and personal liberty, right to move in out of the country and come back to the country. Freedom of residence. Every citizen has the right to reside and settle in any part of the territory of the country. This right is two parts: the right to reside in any part of the country, which means to stay at any place temporarily, and the right to settle in any part of the country, which means to set up a home or a domicile at any place permanently. एक टेम्परेरी हो गया और एक परमानेंटली हो गया. This right is intended to remove internal barrier within the country or between any of its parts. This promotes nationalism and avoids narrow-mindedness. The state can impose reasonable restriction on the exercise of this right on two grounds, namely the interest of general public and the protection of interest of any scheduled tribe. The state can impose reasonable restriction on the exercise of its right on two grounds, namely the interest of general public and the protection of interest of any scheduled tribe. The right of outsiders to reside and settle in tribal areas is restricted to protect the distinctive culture, language, custom and manner of scheduled tribe and to safeguard the traditional vocation and properties against exploitation. In many parts of the country, the tribals have been permitted to regulate their property rights in accordance with the customary rules and laws. The Supreme Court held that certain areas can be banned for certain kinds of persons like prostitutes and mutual offenders and for freedom of residence. From the above, it is clear that the right to residence and the right to movement are overlapping to some extent. Both are complementary to each other. That is, right of movement and right of residence. Freedom of profession. All citizens are given the right to practice any profession or to carry on any occupation, trade, or business. The right is very wide as it covers all the means of carrying, means of earning one's livelihood. As a means of earning one's livelihood, the state can impose reasonable restriction on the exercise of this right in the interest of the general public. The state can impose reasonable restriction on the exercise of the right in the interest of the general public. The state can impose reasonable restrictions on the exercise of this right in the interest of the general public. For this, the state is empowered to. The state can impose reasonable restrictions on the exercise of this right in the interest of the general public. Further, the state is empowered to prescribe professional or technical qualification necessary for practicing in profession or carrying on any occupation, trade, or business, and carrying trade, business, industrial service, whether to the exclusion, complete or partial of citizen or otherwise. Carry on by itself any trade, business, industrial service without exclusion. Protection and respect of conviction for offences. Article 20. Article 20 grants protection against arbitrary and excessive punishment to an accused person, whether citizen or foreigner or legal person like a company or corporation. It contains three provisions in that direction. No ex post facto law, not proved suspect in criminal. No person shall be convicted of any offence except no ex post facto law, that is, no person shall be convicted of any offence except for violation of a law in force at the time of the commission of the act. No ex post facto law, no person shall be convicted of any offence except for violation of a law in force at the time of the commission of the act, nor subjected to a penalty greater than the prescribed by the law and force at the time of the commission of the act. No double jeopardy. No person shall be prosecuted and punished for the same offence more than once. No ex post facto law. No ex post facto law. No ex post facto law. No person shall be convicted of any offence except for violation of law, that is force at the time. किसी को भी हम ऐसे फालतू में कन्विक्ट नहीं कर सकते हैं. And force at the time of the commission of the act, or subjected to penalty greater than the prescribed by the law, and force at the time of the commission of the act. No double jeopardy. No self-incrimination. For the same offence more than once, no person accused of any offence shall be compelled to witness against himself. No ex post facto law is one that imposes penalty retrospectively, that is upon act already done, or which increases the penalties for such an enactment of such a law is prohibited by the first provision of Article 20. However, this limitation is imposed only on criminal laws and not on civil laws or tax laws. This is only for the criminal laws. In other words, civil liability or tax can be imposed retrospectively, but this provision prohibits only conviction or sentence under an ex post facto criminal law and not the trial thereof. Finally, the protection immunity under this provision cannot be claimed in case of preventive detention or demanding security from a person. The protection against double jeopardy is available only in proceeding before a court of law or a judicial tribunal. In other words, administrative authorities, as they are not of judicial nature. The protection against self-incrimination extends to both oral evidence and documentary evidence. However, it does not extend to compulsory production of material object. It does not extend. Federal Scheme Officer, Governor, Judiciary, Public Service Commission, Emergency Provision, and Administrative Detail. Government of India Act of 1935, Federal Scheme Officer, Governor, Judiciary, Public Service Commission, Emergency Provision, and Administrative Detail. British Constitution. Parliamentary government, rule of law, legislative procedure, single citizenship, cabinet system, prerogative rights, parliamentary privileges, and bicameral prerogative rights and bicameral US Constitution, fundamental right, independence of judiciary, judicial review, impeachment of the president, removal of Supreme Court and the High Court judges, and post of vice president. Irish Constitution, directive principle of state policy, nomination of members to the Rajya Sabha, and method of election to the method of election of the president and method of election of the president and the method of election of the president. Irish Constitution, DPSP, nomination of member to the Rajya Sabha, and method of election of president. Canadian Constitution, federation with a strong center, vesting of residuary power at the center, appointment of state governor by the center, and advisory jurisdiction of the Supreme Court. That is Article 143. Advisory jurisdiction of the Supreme Court. Advisory jurisdiction of the Supreme Court. Australian Constitution, concurrent list, freedom of trade, commerce, intercourse, and joint sitting of the two houses of Parliament. Mahima Constitution, suspension of fundamental right during emergency. Soviet Constitution, fundamental duties and ideas of justice, social, economic, and political in the preamble. French Constitution, Republic, and the ideals of liberty, equality, and fraternity in the preamble. South African Constitution, procedure for amendment of the Constitution and election of member of Rajya Sabha. यहाँ पे था आयरिश में नॉमिनेशन ऑफ मेंबर टू द राज्यसभा एंड साउथ अफ्रीकन कॉन्स्टिट्यूशन हम लोगों ने लिया है इलेक्शन ऑफ मेंबर्स ऑफ राज्यसभा. जापानीज कॉन्स्टिट्यूशन प्रोसीजर established by law. From the Japanese constitution we have taken procedure established by law. From the Japanese constitution we have taken procedure established by law. Sindhi was added by the 21st Amendment Act of 1967. Sindhi was added by the 21st Amendment Act of 1967. Sindhi was added by the 21st Amendment Act of 1967. 21st Amendment Act of 1967. Konkani, Manipuri, and Nepali. 71st Amendment Act of 1992. Konkani, Manipuri, and Nepali were added by the 71st Amendment Act of 1992. Bodo, Dongri, Maithili, and Santali were added by the 92nd Amendment Act of 2003. Bodo, Dongri, Maithili, and Santali were added by the 92nd Amendment Act of 2003. Oriya was renamed as Odia by the 96th Amendment Act of 2011. Oriya was renamed as Odia. Oriya was renamed as Oriya by the 96th Amendment Act of 2011. 243G, 29 matters of the panchayats and 18 matters of the municipality are mentioned in Article 243W. 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 243W.